Today, mass media and mass communication has been an inseparable part of everyday life. On social media, anyone with internet access can take on the role of writer and publisher. People post on Facebook, Twitter, and other similar social media, potentially spreading their message to an audience of millions with just the click of a mouse. Not only social media, this applies to other mass media like television and newspapers also. When you write something in a newspaper or show something on a television channel, it reaches millions of audience in very less time. But this enormous potential of reaching people has a major drawback. People these days believe everything they see on social media. Today, it is easier than ever to spread lies about people for various intentions and destroy their reputation in just few minutes. So, as a journalist or a media writer, you must have the knowledge of what you should and shouldn't write. You must also be aware of the consequences of your writings. So, it is important to understand the laws and ethics of the media. Media law does not refer to a uniform body of law, but is rather a collection of a variety of laws and ethical standards that influence the work of the media. Also, different forms of media are subject to different regulations. Nevertheless, there are universal rules that need to be respected by all journalists and media writers when practicing their profession. Only when they adhere to the generally accepted legal and ethical principles of their profession can they fulfill their main function in a democratic society. Media law is a branch of law that consists of a system of legal norms that regulate the activities of the mass media. It examines the limits within which media outlets and journalists can operate. Media law, on the one hand, regulates the principles of the dissemination of media products, and on the other hand, it can affect the format and content of media products. Some regulations apply only to specific types of media. For example, there are broadcasting laws that apply only to the activities of broadcast media. More general legal provisions are to be respected by all media. The law relating to mass media does not constitute a single field of law, but is rather comprised of a diverse set of laws and provisions that are scattered across the entire legal framework. The foundations of the principles of media law can be found in the constitutions of many countries, specific national legislation as well as international conventions and acts dealing with this subject. Protection of the freedom of expression, freedom of the press, and in some cases the right to access to information is guaranteed in the Indian Constitution under Article 19A. Also, the prohibition against the censorship of the media and the right of access to information is enshrined in constitutional law. General provisions related to the licensing of broadcast media are also subject to constitutional provisions. Criminal law regulates criminal acts and their consequences, and in turn, the relationship between individuals and the state. Sometimes violations brought by the media or individual journalists can be subject to criminal prosecutions, for example, libel or slander, defamation of business reputation, insult, incitement to racial or religious hatred, etc. Civil law regulates interactions between individual legal subjects, including both natural persons and legal persons. Civil cases related to the media and journalism can involve liability in relation to the damage of honor or civil reputation, copyright issues, right to one's own image, etc. Broadcast media plays a central role in the functioning of modern societies, in particular in the formation and transmission of social values. For this reason, the broadcasting sector is subject to specific regulations based on common values such as the freedom of expression, pluralism, copyright protection, the promotion of cultural and linguistic diversity, the protection of minors and of human dignity, etc. In most democratic countries, broadcast regulators serve two primary functions. The first is overseeing the allocation of broadcast frequencies through the award of licenses. Secondly, they develop and implement codes of conduct that deal with various content and broadcast practice topics. The Cable Television Networks Regulation Act 1995. The principal purpose of the Act was to introduce regulatory certainty to the cable market that had emerged in the early 1990s. The Statement of Objects and Reasons declared that cable TV constituted a cultural invasion as cable programs were predominantly Western and alien to Indian culture and way of life. It declared that the lack of regulation had resulted in undesirable programs and advertisements being shown to Indian viewers without any censorship. The Cable Television Networks Regulations Act 1995 was enacted for the purpose of regulating the operations of cable television networks in the country so as to bring uniformity in their operations, avoid undesirable programs from being made available to the viewers, as well as to enable the optimal exploitation of the technology which had the potential of making available to the subscribers a vast pool of information and entertainment. Section 3 of the Act mandates that a cable television network can be operated only by a registered cable operator. In order to register, an entity could be an Indian citizen, an association of individuals whose members are Indian citizens, a company in which not less than 51% of paid-up equity share capital is held by Indian citizens. The Cable Networks Act empowers and authorizes a government officer to seize a cable operator's equipment if the officer has a reason to believe that the cable operator is functioning without proper registration. The introduction of the Prasar Bharati Bill in Parliament in May 1979 was a direct result of the recommendations of the B.G. Varghese Committee set up in 1977 after the internal emergency declared by the Prime Minister Indira Gandhi. The bill was allowed to lapse after the Janata Party government elected to form the government after the emergency collapsed and the Congress Party returned to power. The victory of the National Front government in 1989 saw the revival of the Prasar Bharati Bill in a somewhat modified form. The bill was passed by the Parliament and received presidential assent on September 12, 1990. The Act provided for the formation of an autonomous broadcasting corporation and that would manage Doordarshan and AIR, All India Radio, discharging all powers previously held by the Information and Broadcasting Ministry. The corporation would inherit the capital assets of Doordarshan and AIR and would be managed by 15-member Prasar Bharati board, including the directors general of the two organizations and two representatives from amongst the employees. The chair and other members of the board would be appointed on the recommendations of the select committee headed by the vice president. A 15-member broadcasting council would address public complaints. Given the role of the media as a government watchdog, the regulation of media activities by the state, the very entity being observed, can be challenging. That is why many states have established self-regulatory mechanisms which set up specific rules for the media and oversee the compliance of those rules through fellow media organizations and journalists. Self-regulatory instruments can take the form of ethics, codes, press and media councils, and professional guidelines. Journalistic ethics codes define the roles, rights, and duties of journalists and are developed by the collaborative endeavor between media professionals to create voluntary editorial guidelines to abide by. Journalistic codes of conduct vary in different countries but also share some common elements, including the principles of truthfulness, accuracy, objectivity, and impartiality, the right of the public to truth, the right to fair comment and criticism, the use of fair methods to obtain information, the willingness to correct mistakes, and respecting the confidentiality of sources. Introducing a code of ethics is merely the first step towards effective media self-regulation. In order for self-adopted codes to be upheld, it is also important to establish an independent body to supervise and impose sanctions against individuals or organizations in violation of those principles. Alongside journalistic codes of conduct, journalists should also be guaranteed editorial independence in order to work without being subject to pressure from the commercial interests of media owners. A third important element of self-regulation is the professional guidelines adopted by media organizations as part of their editorial policy. The BBC is an example of a media organization that has adopted strong professional guidelines that have heavily impacted the content that they publish. In India, self-regulation of content in the broadcast media is conducted through a two-tier mechanism of self-regulation by individual broadcasters as well as industry-level regulatory bodies. Regulation of content is divided into news and non-news sectors. For the non-news sector, industry-level regulation is enforced by the Broadcasting Content Complaints Council (BCCC) within the Indian Broadcasting Foundation (IBF) that oversees channels other than the news and current affairs channels. The BCCC hears complaints and may issue directions to the channel to modify or withdraw the objectionable content and can further fine the channel up to Rs 30 lakhs. If the direction is defied, the matter may be referred to the Ministry of Information and Broadcasting for further action, including revocation of permission to broadcast. The self-regulatory body for news and current affairs channels is the News Broadcasters Association (NBA), which has set up the News Broadcasting Standards Authority (NBSA) to adjudicate complaints in relation to broadcast content of news channels. The NBA consists only of organizations that are members and submit themselves to regulation by the NBA. Therefore, the jurisdiction of the NBSA is restricted only to members. The NBA has in place a code of ethics to regulate television content. The NBSA is empowered to warn, admonish, censure, express disapproval and fine any broadcaster in violation of the code a sum up to Rs 1 lakh. Print media in India is governed by the Press Council Act 1978 that establishes the Press Council of India. The council comprises a chairman and 28 other members. The chairman is to be nominated by committee constituting of the chairman of the Council of States Rajya Sabha, the Speaker of the House of the People Lok Sabha and the person elected by the members of the council. The Press Council of India is statutorily empowered to take suo motu cognizance or entertain complaints against newspapers and journalists accused of violating standards of journalistic ethics or offending public taste and censure. It may summon witnesses and take evidence under oath and issue warnings and admonish the newspaper, news agency, editor or journalist. However, the Press Council of India does not have the power to penalize any entity for violation of its guidelines. Freedom of expression is the ability to hold and openly express one's opinions or ideas without fear of censorship or government interference. The right to freedom of expression is not limited to verbal communication, but also includes the ability to express one's view through published articles, books or leaflets, television or radio broadcasting, works of art, the internet and social media. It also includes the right to receive information through various communication channels. The Indian Constitution does not provide freedom for media separately, but there is an indirect provision for media freedom. It gets derived from Article 19(1)(a). This article guarantees freedom of speech and expression. Article 19 of our Constitution deals with the right to freedom and it enumerates certain rights regarding individual freedom of speech and expression, etc. These provisions are important and vital, which lie at the very root of liberty. Article 19 of the Indian Constitution lays down all citizens shall have the right to freedom of speech and expression, to assemble peacefully and without arms, to form associations or unions, to move freely throughout the territory of India, to reside in any part of the territory of India, to acquire, hold and dispose of property and to practice any profession or to carry on any occupation, trade or business. However, freedom of speech and expression is not absolute. As of now, there are 8 restrictions on the freedom of speech and expression. These are in respect of the sovereignty and integrity of the country. These 8 restrictions were security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, incitement to offence, sovereignty and integrity of India. Every writer who writes for newspapers, television, websites or who wants to publish a book must have a basic understanding of the legal restraints he is working within. The main legal areas are copyright, defamation, blasphemy, seditious libel, criminal libel, right to privacy, reporting restrictions, law and internet, etc. Copyright is an intellectual property right protecting things that are created by a person's skill, labor and investment in time and money. You will find that most published works will state, usually in the first few pages, that no part of the publication can be reproduced in any material form without the written permission of the copyright holder. The law is designed to protect an individual's own material such as articles, programs, scripts or songs, as well as those who publish the material such as newspapers, broadcast and film and music producers. In relevance to the media, copyright is a serious consideration. It determines the extent to which a quotation or the work of a third party can be used in an article or broadcast. A writer as well as the print and broadcast media can maximize the potential of their own work, example an exclusive interview or first seen footage of an event, and prevent others from using it. This is a powerful advantage in the media industry. Copyright does not extend to an idea, nor is there copyright in news. Anyone can report on an event, however, the way the information is expressed is what is considered protected work and cannot be copied, that is, word for word, nor can the footage or photography be used. Defamation protects the reputation of a person from defamatory statements made about him or her to a third party. A person, the claimant, can sue a writer or broadcaster if they feel they have been discredited. The outcome from such legal action can be timely and expensive. What is a defamatory statement? According to Alberstadt, Castles and Overs, a statement of defamatory if it tends to lower the claimant in the estimation of right-thinking members of society generally. The defamation must identify or refer to the claimant and must be published to a third person. Publishers and their editors need to use their discretion when it comes to what is printed. Questions need to be asked. Is the content true and can it be proved? If the content is not true and cannot be proved, the editor need to determine if the person being written about is likely to take legal action. Seditious libel is speaking or writing anything offensive to the government or the representatives of the government. Considered slightly outdated in today's modern society, seditious libel prosecutions are extremely rare, with the last case recorded over half a century ago. Criminal libel is the malicious defamation expressed either in printing or writing or by signs or pictures, tending to blacken the memory of one who is dead, with intent to provoke the living or the reputation of one who is alive and to expose him to public hatred, contempt or ridicule. It has been defined perhaps with more precision to be a censorious or ridiculous writing, picture or sign made with a malicious or mischievous intent. The right of privacy prevents the unauthorized commercial use of an individual's name, likeness or other recognizable aspects of one's persona. It gives an individual the exclusive right to license the use of their identity for commercial promotion. A breach of confidence is when an individual seeks an injunction to prevent the publication of confidential information about them. In order to establish a breach of confidence, a claimant must prove that the information is deemed confidential, the information was imparted in circumstances which suggested confidence, and that there has been or will be unauthorized use of the information. Rapid changes in technology have brought with it new challenges for the law. Many users of the internet promote the freedom of information and consider it a regulation-free media. The global nature of the internet makes it difficult for individual countries to enforce domestic laws, and there is no international body or court with the authority to create the law on the internet. However, it is assumed that those working in the media should apply existing principles of media ethics. Defamation and copyright legislation translates to the internet, and individuals and organizations are responsible for what they publish on the web, whether it is on their own website or someone else's. An unwritten code of ethics has developed which affects the way people use the internet. For example, spam, a term that refers to sending unsolicited email, is generally considered an unethical practice by many internet users, and often individuals or even service providers will take matters into their own hands and take action against spam. This can sometimes impact on people other than those who spam. That consideration raises further questions about ethics. Media law is a branch of law that consists of a system of legal norms that regulate the activities of the mass media. It examines the limits within which media outlets and journalists can operate. The media law could be a constitutional law, criminal law, or civil law. In most of the democratic countries, the broadcast media sector is subject to specific regulations. In India, there are two major regulations. There are the Cable Television Networks Regulation Act 1995 and Prasar Bharati Act 1990.